This is Michael Cowen, and welcome to Trial Lawyer Nation.
He helps us pan for the gold inside ourselves.
You need to have grit. I mean, a lot of this is grit.
I feel like I've been made a better lawyer.
They're talking about something that's real to them.
You have to be really careful not to be Goliath.
They saved a bunch of lives and changed society forever.
But let's just begin the conversation.
Welcome to Trial Lawyer Nation, your source for guidance to win bigger verdicts, get more cases, and manage your practice. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Today on Trial Lawyer Nation, we have attorney Eric Penn with us. Eric's a lawyer from Jacksonville, Texas, and he recently got an $89.6 million verdict in Houston against Warner Enterprises in a big trucking case. It was a tough case, and it was a good case, but the facts were challenging. And I wanted to talk to Eric about, how did you do it? What did you do to work up a case and present a case that would be that compelling to a jury? He agreed to do it. I learned a lot. I think you will too, and it's going to be useful to us in all of our practices. So I hope you enjoy the show today. Eric, how are you doing today?
I'm good, Mike. Thank you.
And now everybody wants to hear about your huge verdict, but before we get there, I want to hear a little bit more about you. So tell me a little bit about you.
Well, I am a 42-year-old single dad of 3 that lives in Jacksonville, Texas. I've been practicing for almost 18 years. I've got a firm that primarily focuses on trucking cases, Texas, or anywhere else in the U.S.
Well, I'm just kind of curious, how do you get from, I just graduated from law school and I don't know what I'm doing, to, I just won an $89 million verdict?
89.7 if you're rounding to the nearest tenth, I guess.
Plus interest.
There you go.
So tell me a little bit about that path.
Well, so I graduated from law school. I clerked for a judge on the Court of Criminal Appeals. My first year out, I came back to what is my home area and worked for and with my uncle for the first 11 years or so after that. And I've been out on my own for the past 6 years. And since I've been out on my own, I have done what I'm doing now, which is exclusive personal injury cases, but primarily focusing on trucking cases and a bit of product liability cases as well. Okay. So that's the 30,000-foot overview of my path from 18 years ago graduating to now.
And what made you focus on trucking cases?
I just have always enjoyed them. We all, of course, can relate to sharing the roads with 18-wheelers every single day. It's something that we as humans outside our lawyer offices can relate to, along with everybody else in the general public. I'll say that I had a lawyer that was a kind of a mentor that told me very early on in my personal injury practice that, as a general rule, a case will never look as good as it did as the day you signed it up. And in my experience, that there's some certain validity to that. But one of the beautiful things about trucking cases is, generally speaking, that's not true. That's the one category of cases that consistently seem to get better the more you roll your sleeves up and dive in. And so that's obviously, in my experience, a fun aspect of doing these cases as well.
That's been my experience too. So how did you, I'm assuming you never drove a truck.
I haven't.
How did you get the knowledge you needed to do to take on and do a great job on trucking cases?
It's just an evolution. You get a case or two and you just kind of dive in metaphorically as well, and you start going to seminars and you start studying up and you make friends with people that have been doing it longer than you, and you pick the phone up and you have the audacity to say, hey, I need to talk to you about this case, and let me just pick your brain, and it just kind of snowballs from there. And that's been my experience for probably the past, I don't know when I took my first trucking case, but probably the past dozen years or so.
And in my experience, to really do well in a trucking case, you have to have a couple things at least. One is you have to understand trucking. You have to understand the rules, the industry standards. If not, you can't prove what they did wrong. You can't tell the full story, and honestly, they can bamboozle you and pull things over you if you don't know what you're doing.
My experience too.
But there's also a whole nother set of skills that you have to have, and obviously your past recent success proves that you have it, and that's the ability to talk to a jury. What have you done to get, again, from being a kid right out of law school to now being an almost $90 million single case verdict winner? What have you done to develop your skills there?
Well, so the last question we talked about was more, in my mind, answering the first part of your question of how in the world do you figure out all the issues you need to know about in a trucking case and how the rules and regulations work and industry standards and develop a relationship with experts in the industry that you need to have to successfully prosecute one of those cases. The second half of your question about how do you combine that with the ability to talk to a jury and relate to a jury. I went to Trial Lawyers College back in 2010.
That's the Jerry Spence College?
Jerry Spence Trial Lawyers College.
I know that because I went there a long time ago, but not all the listeners know that. That's why I'm
got it
in there.
Yep. So I went to Jerry's Trial Lawyers College in 2010 and spent the 3 or 3.5 weeks at the ranch. That was a big deal in my professional life. And I have always, and continue to this day, been a big believer in working with as many consultants as I can to, this is cliche, so I get it, but to put as many tools in my toolkit as I can and have skills to fall back on and rely upon for each case, each witness, each situation, and just try to figure out what works best for me, which has all been very helpful. But I would say, again, kind of going back to the base of your question of, how have you gotten to the point where you can talk to a jury? Trial Lawyers College was the most influential there, of just learning to, within myself, get to a place where I can be what I consider an open book and be authentic and sincere and genuine to the point where real juries and real people that sit out there say, look, I don't know what's going on with this guy. Maybe I do agree with him, maybe I don't, but at least this guy's real. And that, in my experience, in my opinion, is probably the most important thing that any trial lawyer can learn, regardless of what kind of case they're trying.
I'm a harder study and thicker-headed than most people. I needed the Trial Lawyers College plus the working with Mike Luserman at his 3-core workshop was kind of what put me over the edge.
Which, of course, you and I think were in Chicago.
That's right. I met you there.
Luserman and Josh Carton. And so, yeah, similar concepts, working with Mike and Josh. And
that's funny. I forgot that's where I met you, because I've met you at so many different things and never in Texas. This is like, I think, the first time I've had a conversation with you in the state where we both live.
Funny how that works.
But I totally forgot that. But that to me was the I don't remember. I had to give an opening statement when people were yelling all my insecurities into my ears, and that has been the most transformative. It was not pleasant, but the most transformative part of my practice.
Absolutely, yeah. And all that, as you know, working with Michael and working with Josh Carton, different spin but similar kind of base concepts of what we learn and work with at Trial Lawyers College, and so all very helpful to me as well.
And so, before you got to your latest great victory, how many cases had you tried?
I should know this, and I can look it up and tell you exactly, but approximately 20 cases, I'd say. And so I'm an 18-year lawyer, and I've averaged at least one a year, maybe a bit more in my career.
I guess that's the advantage of not taking a bunch of trash cases like I used to do. You get to try more, but you don't get to put as much attention to each one.
Right.
So let's talk a little bit about this case then. What's the name of the case?
So my client's is Jennifer Blake and her 3 kids. So the style of the case is Blake versus, their driver's name was Ali, but Ali v. Warner.
Okay. And tell me a little bit about the facts of the case.
So the basic facts are my clients, I represent a mom and 3 kids who are all passengers in a Ford F-350. Our truck was being driven by a close family friend. They had gone and run an errand in Pecos, Texas, which was about an hour and a half where they lived. They were on their way back on Tuesday, December 30th, 2014. They left Pecos about 3:30 in the afternoon. As they were heading back to Midland, which is where they lived, about 10 miles outside of Odessa, west of Odessa, they unknowingly to them hit an area where There had been freezing rain, creating black ice on the highway.
Which you can't see.
Which is why they call it black ice. Ice that we can see, we call ice.
Right.
The reason we created another name for it is because this is a phenomenon that we can't see, and it's honestly the most dangerous or most hazardous road surface condition, in my opinion, there is. One, icy roads are in general, but two, a black icy road that you cannot see, a hazard that you cannot perceive and therefore can't react to is extremely dangerous.
And then I read something interesting. I'm preparing for a similar case that in states like Texas, where we don't have it all the time throughout the winter, is even more dangerous because people aren't used to it. They're not practiced with it, as in Michigan they would be.
Absolutely.
Sorry to interrupt. But.
No. It's a critical point. And this maybe it's a different case if it happens in Michigan or if it's even tried in Michigan, but it's not. It happened in Texas and it was tried in Houston, in Harris County, Texas. And I'm a born and raised Texan myself, and I can probably count on one hand the times that I've ever encountered any type of black ice, and so it's a big deal. So our driver, our vehicle, had been in the black ice for approximately 5 miles. Didn't know it. Hit a patch, lost control, spun through a grassy median on I-20, came up into the left lane, opposite bound lane of traffic. And was annihilated by a Werner 18-wheeler. So when you first hear those facts, the first question I had, and anybody that hears that has, is what in the world did the 18-wheeler driver and the company that sponsored him do wrong to create this?
Yeah, I was going to say, who did the police blame?
So the crash report in this case had no fault on anybody.
Oh, really?
It was an unusual crash report in that sense. And so the police concluded that there was nothing that the 18-wheeler driver could have done to avoid the crash, and there was no way that the driver of our vehicle could have known he was in black ice.
Okay.
And therefore found no contributing factors on either driver.
That's unusual. Now 98% at least of the plaintiff's lawyers in the state of Texas would have said no thank you to that case.
I think that's probably accurate.
What is it that you saw that made you think, I want to look a little deeper instead of just saying no?
So that's a question I get asked a lot, and here's the answer. Tragically and unfortunately very apparently up front, the injuries to my client and her 3 kids were devastating.
Tell me about that.
Her youngest son, Zach, was 7 and died 3 days after the crash. Her only daughter and middle child, Brianna, who was 12 at the time. When I was hired on the case, I think Brianna actually was still comatose and in a vegetative state, but it was clear she survived, but she had a catastrophic brain injury that rendered her a quadriplegic, and again, I think she was still probably even vegetative at the time. And then even Mom and Nathan, her oldest son, suffered various orthopedic injuries, were ultimately diagnosed with mild traumatic brain injuries. And so the point is, initially up front, it was tragically clear that the damages that this family suffered were horrendous, and to use lawyer speak, the damage model was kind of off the charts. And so that's the first thing that it was apparent when the case walked in my door. The second thing is, even though the crash report did not fault the driver of the 18-wheeler, it did document that the road had black ice on it. And it documented that black ice is what caused the driver of our vehicle to lose control. So you and I know, doing this, there's 2 main rules and sources of industry rules that are on point in a case like this where you have icy roads. You have 392.14 and the FMCSRs. And
that's the Federal Motor Carrier Safety Regulations?
It is. We call it the Green Book.
Right. Just because not everyone listens to this does trucking work. That's it.
Fair enough, yes.
Excuse me, I'm treating you like an expert. I'm making you speak English.
Fair enough. I don't like talking like a lawyer, so I appreciate the reminder of that. So yeah, there's two sources of rules, one from the federal government, and then we have the state CDL manuals, or commercial driver's license manuals, as they're roughly called, that every single state in the union has one. And I knew that The federal rule said you have to exercise extreme caution in those conditions, and more importantly, and kind of on point, the state CDL manuals say that when you hit an icy road surface, you slow to a crawl, which in the trucking industry is defined as 15 miles an hour or less. And then more importantly and secondly, you stop driving as soon as you can safely do so in those conditions. And I could see the DPS photographs from the day of the crash at the scene. The damage to the vehicle that my clients were passengers in was massive. And in my lay opinion, it looked like that the speed differential between, our truck and the 18-wheeler must have been, it was massive as well. Certainly looked like, just from a lay kind of opinion, that the truck must have been traveling much faster than 15 miles an hour. And so kind of knowing those three facts, the severity of the injuries to my people, what the rules are for trucks in those conditions, and then what the photographs of the trucks or the property involved, I guess the vehicles involved, said, look, this is a case that we need to at least go do downloads, see what the speeds of the vehicles are, preserve and capture the evidence that's around, and then let's see what we have.
Now, I now understand your case, but my initial thought when I heard about it, I've been kind of following your case for a little over a year, was, well, so what if he's driving too fast? He's got the right of way. He didn't lose control. What could he have done to avoid the wreck? I mean, how did you address that? I mean, even in your own mind.
Well, so our case was about everything but the 3-second crash sequence.
Okay.
So in many ways, it's funny. We had observers of the trial kind of make the same comment, which I actually took as a compliment. You've been out to work with Rodney Jew, so you understand with this concept too. We really did try two different cases in many aspects. And the trucking company's case, and all I wanted to talk about was the 3-second crash sequence, beginning when our truck hit the black ice, started to fishtail, goes through the median, and then we have the crash. All of that, both reconstructionists agreed, was a very quick sequence that lasted about 3 seconds. Our case was about everything but that, including both what happened prior to the start of the 3-second crash sequence and what happened after the crash. As far as the trucking company's conduct post-crash, we had a punitive damage claim that survived summary judgment and went to the jury, and so post-crash conduct is relevant to the concept of conscious indifference and a punitive claim. And so, as we know, the case is about what you make it about.
Yeah.
And so we made it about everything but the 3-second crash sequence, because honestly, it's not a lawyer trick. It was the truth. The police officer agreed when he gave testimony in this case and explained his opinion that he wrote in the crash report that there was nothing that the 18-wheeler driver could have done to avoid the crash. All he was talking about was once that 3-second crash sequence began.
Right.
He gave no opinions, and he made it crystal clear for the jury about anything that happened before that 3-second crash sequence, or certainly after the crash, because he didn't have any of that information. And as he said, and we agreed completely it was appropriate, that's all up for the jury to decide. And so once we dove in and started understanding what had gone on that day, what were the forecasted weather conditions that day, when the drivers and the trucking company made the route selection to go across I-20 in the first place, started looking at this guy's training, his relative experience, his supervision from a trucking company, and then you kind of started even peeling back even further from that and started looking at what safety systems that this company had in place or did not have in place from choices that were made, sometimes even years prior to this crash, and you started putting it all together, and it told a story that was very powerful that said we have a trucking company that are making choices and have been for years that did not put the safety of the rest of us that are sharing roads with these guys every day at the forefront, and that's what they should have done. And the jury understood that story, and they expressed their opinion of this company through this verdict, and it was crystal clear.
Absolutely, and the jury that heard all the evidence understood that, and I've engaged in some lively debate with some other people on social media about this particular case, and one of the contentions I hear is like, well, but since it didn't matter, who could say that they even could have avoided the wreck if they're going slower? And I guess you could say as a matter of physics they wouldn't have got there. But what are the reasons for having this rule that you have to slow to crawl and get off the road when you can? Is it just so you don't lose control? Yeah, so let's do this. I'm going to take kind of both parts of your question, and I'll try to take them in the same order you did. As the first thing is who's to say we're not going to have a crash even if you had gone slower? Well, the beautiful uncontested answer to that question in our 6-week jury trial was both accident reconstructionists agreed and said if he had been going 15 miles an hour at any point prior to the start of the 3-second crash sequence. In other words, let me say it kind of another way. If I gave you the summary, which we don't have time here today, of the 23 different things that we say this trucking company and even the 11 more things we say this driver did on the day of the crash that were all negligent conduct. If you said, even if they blew through every single one of those, but if for whatever reason they finally got it right and decided to follow the rules that are designed to keep the rest of us that share the roads with these guys safe, and at that last minute or second at the start of that 3-second crash sequence, he had slowed to 15 miles an hour, both reconstructionists agreed that there would not have been a crash, there would have been no impact, and it wasn't even close. In fact, Werner's Reconstructions, who was our go-to guy in all these cases, testified that it was a mathematical fact that there would have been no crash if he'd have been going 15 miles an hour, even as late as the start of that 3-second crash sequence. Wow. So that's the answer to your first question that was undisputed, and it really was. You and I know the only reason that Andy Irwin agreed with that and gave us that testimony because it was true. It was a mathematical fact that there would have been no crash if he'd have followed the rules. Now, all of these rules, and when I say these rules, again, the two kind of primary foundational sources in the trucking industry are first the Federal Motor Carrier Safety Regulations and then the CDL manual safety rules that come out of and are required by the FMCSRs. And the whole purpose of all of these rules are generally to protect all of us that share the roads with these guys every single day. And in fact, when you look in the Green Book that we all talk about, the Federal Motor Carrier Safety Regulations, the chapter that requires and sets all the standards out for commercial driver's license manuals is Chapter 383. And the very first sentence in the whole chapter says that the purpose of this chapter and all the rules in it are to prevent crashes and save lives. Yep. And so, we talked to the jury about that at length, that, hold the book up in front of them. Every single thing in here, the whole purpose of it in general is to prevent crashes and save lives, and it's for all the rest of us that are sharing the public roads with these guys when we load our kids up in our cars and get out there on the highways. And so you start with that premise that nobody can dispute. And even this trucking company in this case that disputed every possible thing you can imagine had to agree with those general kind of foundational concepts. Then you start looking at the two source rules that say this is what a driver of an 18-wheeler is supposed to do when they hit hazardous conditions or icy road conditions, like in this case. And it was critical for the jury to understand, and they did, that the purpose of those rules is not so much because the 18-wheelers can lose traction on slippery road surfaces. That certainly is one of the purposes, but it's even more so because we all know and have for decades that the rest of us in passenger vehicles that are not professionally trained drivers are more likely to lose control on those road surface conditions. And if that happens in front of a 30 or 40-ton 18-wheeler that's going highway speeds, we know what the results are going to be to the people in the passenger vehicle. And so the purpose of these rules does not require or rely upon the 18-wheeler maintaining control. It says that these are so dangerous for all the rest of us sharing the roads with these guys that they have to slow down whether they can maintain traction or not under these types of conditions. And one of the examples we kept talking to the jury about, just kind of using popular culture and stuff that are on TV these days, is ice road truckers. Even if you hadn't seen the show, most of us have at least seen a commercial and know what the program is. And
we all know that an 18-wheeler can drive on an icy road and maintain traction. But the difference between the guys driving 18-wheelers and ice road truckers are they're not on our interstate highways in the lower 48, driving at highway speeds with the rest of us and our kids in the car. And so when you have that happen, say on I-20 in West Texas, on a day where the National Weather Service 12 hours before our crash says there's going to be freezing rain, creating ice on the highways, making driving conditions extremely hazardous, that is so hazardous, we don't care if the 18-wheeler slips and slides or not. We say you have to slow or crawl and get off the road as soon as it's safe to do so for the protection of the rest of us for exactly what happened in this case.
In fact, even if you look at the DOT has a preventable accident manual, which is something they make for trucking companies when they look at their wrecks to say, okay, what happened here? How can we keep it from happening again? They say one of the dangers in icy roads is that other vehicles can lose control. And I think that's such an important thing in trucking is that, we're giving as a society these companies permission to put an 80,000-pound vehicle on the same highway with 4,000-pound vehicles and 3,000-pound vehicles. And, the difference, the 80,000-pound vehicle wins when those two hit. And so in exchange for being able to profit from doing that, from doing something that's potentially dangerous, is you have a set of rules. You actually sign under oath you promise to follow. Obviously, as you proved, jurors can understand it when they don't. But I'll be honest, I'm going to take your case. I've got the Federal Motor Carrier Safety Regulations. I've got the Commercial Driver's License Manual. Okay, the truck did wrong. Your driver may or may not have done wrong. I mean, if it's black ice, I can't see it. Well, maybe not. That's probably not enough to get an $89 million verdict and get joint and several liability more than 51% on the trucking company. What do you do now? Okay, so I've got horrible damages. We know they broke a safety rule, but how do I find my case? How do I find what I'm going to tell the jury? What did you do?
It is always about the company, right? So especially when you have a case where, as in this one, our defendant was one of the largest trucking companies in the U.S. They've been in business for 65 years. These guys know what they're doing, and they make a ton of money. They were a $1 billion company with a $2 billion gross annual revenue, running their roads trucks up and down our public highways. And what jurors understand, and again, my case was a long trial, and so they sat through 5 weeks of evidence and another week of arguments and deliberations, that the companies, especially these big ones that put these trucks on the road and make the decisions to have the policies in place or not in place that are designed to either keep us safe or not, are much more responsible when something like this happens than the 24-year-old student driver that had been out of truck driving school for 3 weeks and had less than 1 week's worth of real-world experience, like in our case.
How did you find all that stuff out?
Well, you roll your sleeve up and you dive in.
So what did you do?
That gets back to what we talked about earlier. These cases just generally get better and better the more work you do. So, you start out with you send all the discovery, the written discovery. You go through the dance where companies like this, they don't just say, okay, fine, here's all the answers. You go through the 2 or 3 motions to compel that it always takes initially to get them to turn over what they should have in the first place. We spent a lot of time and effort and resources working this case up from the beginning. We took the case out to Rodney Jew and before we took our first deposition.
Rodney Jew's a litigation strategist out in California that's really good. Thanks to you, I've worked with him once, but not cheap.
Not cheap, but look, it's like everything else. You get a case and you're trying to justify what the case will allow as far as expenses and working with people to maximize the value, and this one was one. Look, let me back up. This is the type of case that you'll understand that when you decide to dive into a case like this, you pretty much understand and just make the decision up front that this case is going to have to be tried.
Right.
The damage model is so big, and at least everybody can understand on first blush the trucking company is going to think that they have a defensible case from a liability standpoint. And so the odds of them offering enough money that it would take to be meaningful for this family with this catastrophic of a damage model under these liability facts are just very small.
Well, that's Eric Penn, because I'm going to be honest, a lot of lawyers, well, first of all, a lot of lawyers I know wouldn't take the case. Of the ones that take the case, I think 90% of them would have worked it up, and whatever was offered before that trial, they would have thought, okay, well, I can get $1 million, $2 million, don't spend too much money, let's get it done. But you didn't do that.
No, I didn't, because that didn't do any good to our client, right? Yeah. At the end of the day, I've got a mom and 2 surviving kids that were devastated, one of which is going to require 24-hour care for the rest of her life, and a couple $1 million literally does them no good. Yeah. And so you understand that up front, and you kind of grapple with that before you decide to take the case and dive in. And if you, in my opinion, and what we did in this case and would do with this case, if it walked in our door tomorrow, is you say, look, the only way I'm going to dive into this is if I can do it right and I can have meaningful result that helps these people that need it so much. And it was just the setup of this case meant almost assuredly from the beginning that means we're going to have to try the case.
That's awesome. So, Eric, what are some of the other things you did to do the work that you needed to discover the story to tell in this case?
We did a whole bunch of work, and we might have talked about this before our break, but we did a whole bunch of work before we decided to start taking depositions in this case. The first deposition we took was the safety director for Werner, and we'd spent a bunch of time and effort really developing the case before we did that, and it really paid off. And the bottom line is we were way more prepared than they were and she was for that initial deposition. It was very productive for us.
So what kind of work did you do?
Well, so we had, and I can't remember how many. I think we ended up doing probably 15 focus groups in this case by the time it was all said and done. But we had done at least 1 or 2 before that first deposition. We'd taken the case out to Rodney Jews, who we talked about earlier, and spent a week out there working the case up and developing the case.
You spent a week just working on one case?
Just one case before we took the first deposition in the case. And
so by then you already knew what industry standards, what literature, how to sequence things.
We knew where we wanted to go, how to sequence things, and the kind of roadmap that we thought we had from what we could tell from the case, just from the written discovery phase that we'd gone through up to that point. And bottom line is we were way more prepared than either the company, their lawyer, or their safety director was when we started diving in with these depositions. And so that was critical and a big advantage for us. And then, this case was interesting and had several nuances to it. As it turns out, one of the most significant ones was we took 2 corporate depositions first, and then we took the 2 drivers were the 3rd and 4th depositions we took in this case. So there was a student driver behind the wheel at the time of our crash. He had a driver trainer in the truck with him. When we took those 2 depositions, one of kind of the foundational pieces of evidence and facts in this case that we did not expect to be in dispute, we learned for the first time were in fact in dispute. And that is both drivers, when they were deposed, said they never drove across one speck of ice on I-20 at any time from the time they left the yard in Dallas until the time of our crash. The roads were not icy, in other words. The crash report documented the roads were icy. Our clients, of course, told us that was their recollection once they were on the roads post-crash, that they were icy and slippery. And we just did not anticipate up until that point that was going to be a contested issue in the case. We hear these 2 drivers' story that both say there was never any ice on the road, and so we find that out for the first time that all of a sudden it is.
What do you do to address that?
So we again rolled our sleeves up and kind of dove in. We said, okay, accept the challenge, and let's go just see what the evidence is as far as ice on the roads. And so there was an oilfield services yard that was adjacent to the crash site. I immediately went out there, knocked on their door, said, hey, here's what's going on. Were you guys out here this day? Yes, I was. What did you see? What do you remember? They heard the crash. They responded to the crash scene within 60 seconds of the crash was their estimate. And these guys described slipping and sliding across the highway to get to our clients in the vehicle.
And I want to take a break. You said, stop you for a second, you went to the oil field place that happened by the wreck. Where the wreck happened?
10 miles west of Odessa.
And where do you live?
I live in Jacksonville, Texas.
So how far did you have to go to personally go and check on this company?
Well, it was about an hour and a half plane ride, and then,
But hundreds of miles.
Hundreds of miles. And that was our first indication that we had people on the scene almost instantaneously that said the roads were icy. We then started identifying other people that responded to our scene. We ended up talking to every single first responder that was involved in this crash, whether it be a police officer, a firefighter, EMT, ambulance driver. All of them confirmed and said in one fashion or the other that the roadway was covered in ice. We then went out and said, okay, we found the National Weather Service winter storm warning that said 12 hours before our crash there was going to be this huge area in West Texas, Ector County, where the crash happened included, that was going to have freezing rain accumulating into ice, making driving conditions extremely hazardous. We also saw that the warning that came out at 4:26 this morning says it will develop, meaning the freezing rain. They issued a warning at 2:50 that afternoon, which was approximately 100 minutes prior to our crash, that said the freezing rain has developed.
Oh, wow.
We all know that freezing rain is the condition that creates black ice. And so we had this evidence that the ice was in the area for an hour and 40 minutes or so prior to our crash. We said, look, this can't be the only crash in this area with black ice conditions. And so we went out.
And I would say, right there, most people would have stopped. Okay, we got them. The Weather Service said it. The people that came out there. You guys didn't stop there, though, did you?
No, we didn't. Because, look, this is a big case. It's a big company. They got all the resources in the world. And so we wanted to make sure we left no stone unturned. So we went and called the state of Texas, and we said, all right, let's start with the area that the National Weather Service said it was covered by the winter storm warning. Let's come from east to west, the same way that the Warner truck was going. Let's also start from Pecos, Texas, which is where our clients left from, and let's go west to east. And let's order every single crash report for this area on this date from the time of our crash or earlier. We said if it happened after our crash, it's not really relevant to understanding what was going on with road surface conditions at or before, but if it was 4:30 or less, then let's order it and see what happens. And then we filtered those crash reports and said, all right, we only want to look at crash reports that document an icy road surface or ice somehow as a contributing factor to causing the crash. And once we kind of filtered through that, we found, I think there were 65 other crash reports.
Wow.
Before ours, on this date, in this area, all but one of which were coming from the east to the west, which is the same direction that the Warner truck was coming, only one of which was west of our crash scene, meaning the direction that our clients were coming prior to. Then we hired a meteorological expert that one of the things he did was he accessed federal databases or something called the National Climatic Data Center that is charged with creating and keeping statistics for weather events like this. And they documented hundreds of crashes in Midland and Ector County on this date, all ice-related.
Wow.
And then we started looking at it, and out of these literally hundreds of crashes documented in 65 crash reports, not one of them involved an 18-wheeler losing control on icy roads. They all involved passenger vehicles losing control in black ice conditions on icy roads. Again, kind of going back to the foundational purposes of these rules, because we know that this is what happens in these type of conditions.
I really normalized your driver, too, I think.
Absolutely. He's doing the same thing that hundreds of other people were doing in this area, in this place at this time, unknowingly driving into black ice, losing control, and having some form of crash. Now, the other thing we found was out of these hundreds of other people that did the same thing our driver did, there was not one other reported incident of a death or catastrophic injury other than the people in our vehicle.
Wow.
And, of course, the explanation for that is Luckily for everybody else, and unfortunately for our people, the difference was that our people had the misfortune of doing the exact same thing as everybody else in front of an 18-wheeler driver that was not trained on the rules and was not following the rules. They were all designed to keep us safe in these conditions. Then we started digging even further, and when we started analyzing the 65 crash reports that we had, we found 3 sets that were very interesting to us, and here's why. They were all crashes where the police officer documented roadway covered in ice with real-time observations on the scene at the time. In other words, what would happen is this. We'd have these crash reports that would say there was a crash at 3 o'clock that afternoon. Well, the police officer wouldn't get there till 3:45. Werner's arguing, well, he may have said it was icy when he got there, but he can't tell us what it was like at 3 o'clock because he wasn't there. He didn't know. It wasn't a real-time observation. Well, 3 of these were police officers that were already on the scene, 2 of which were already on the scene for working a prior crash.
Oh, wow.
They witnessed a second crash. So when the second crash happens and they document roadways covered in ice, we deck their depositions. They confirm, yeah, I was standing right there. It was real-time observation. So that took the knees or took the wind out of that type of argument from Warner. Out of these 3 crashes, there were at times, 2 of which they were clearly before the Warner driver came through driving the same area. So we documented that this kid passed a crash on the side of the road with the car turned over upside down. Police officer responded to it with his emergent lights on, and this guy blows past it not once, not twice, but 3 different times prior to our crash scene. Out of the 3 of those, 2 of those, interestingly, involved passenger vehicles that did the same thing we did. They hit black ice. They lose control. They go through the median into the opposite bound lane of traffic, and they get hit by the opposite bound lane. Nobody was injured in either of those 2 cars because those 2 cars, the people that hit those 2 cars were going slow. But most importantly in this case was one of those involved a crash that was 52 miles east of ours, but happened at basically the same time that the Warner driver came through there. There was a 74-year-old lady that was in the left lane, westbound, I-20. She comes around a corner. She's going approximately 70 miles an hour. There's an 8 to 9 car pileup, ice-related, in front of her in the interstate. She sees it. She hits her brake. She reacts to it. When she hits her brakes, she loses control. She goes through the median into the opposite bound lane of traffic, and she gets hit by an 18-wheeler. This was also, again, witnessed by the police officer that was there working the pileup and saw it with his own 2 eyes. And so we ended up, it took us a while. It took us a long time, actually. But we found all 3 of those people. We found the police officer that witnessed it. We found the 74-year-old lady that lost control. And we found the truck driver that hit her. And what they told us was this. Her name was Helen Myers. I'll never forget her. Beautiful lady. And when I finally got her on the phone, she'd moved to Tulsa, Oklahoma. And she said, yes, Eric, I remember that day. It was crazy. And I told her why I was calling her and what my involvement was. And asked her what her experience was in that crash. She said, Eric, I wasn't even sore the next day.
Wow.
And
74 years old.
74 years old, who was going faster than our vehicle was, and a smaller passenger vehicle got hit by an 18-wheeler. And not only did she walk away, she came and testified to the jury the same thing she told me on that phone that day, that I wasn't even sore the next day.
You got her there live from Tulsa?
Got her there live.
How'd you do that?
I said, ma'am, this is really important. I really appreciate you talking to me, and if there's any way I could get you to come to Houston and tell that jury in person, I'd love it. She said, absolutely, I'll be there.
Wow.
And then the last one, it took us a long time. He wasn't I guess he was a reluctant witness.
Right.
But we finally found the truck driver that was involved in that crash. And this was a 39-year professional driver that said, I recognized that I was in freezing rain. I recognized that the outside air temperature was below freezing, so I knew what that meant. I couldn't 100% tell you that the roads were icy, but I knew all that kind of added together, they probably were. I had just passed another crash. All of that told me, more likely than not, the roads are icy. I know what the rules say. And he told us that at the time that Miss Myers came coming through the median and prior to the impact, he couldn't have been going any more than 5 miles an hour.
Wow.
And so the jury in this case, what we got to talk about is that the purpose of these rules, that we know the rest of us are more likely to do this and lose control in black ice conditions, and we know what the consequences are going to be if they're going highway speeds. This isn't a theoretical discussion. We have real world, real human being examples on this place and this date at this time that show that when this rule is followed, it works to serve its purposes, which is to ultimately save lives. And so we had two different vehicles, passenger vehicles, do the exact same thing. One where the 39-year-old pro follows the rule and the 74-year-old lady's not even sore the next day. And in our case, where the 3-week student driver that was unsupervised on a time run was not following the rules, and Zach died 3 days later, and Brianna was a quadriplegic to the point that she can't eat, walk, or talk for the rest of her life.
Poor baby. So I get now how you show that truck driver broke the rules, but when the jury gave percentages after they gave the liability before they gave the dollar amount, what were the percentages?
70% Werner, 14% Werner's driver, 16% the driver of our vehicle.
So how was it then you went from, okay, Werner's driver didn't follow safety rules to it being more than 4 times more of Werner's fault than their own driver's fault, or then the driver, frankly, that lost control and ended up in the wrong lane's fault?
Well, and this is where, if we had another hour in your podcast, I could do a better job answering this, for summarizing the evidence the jury saw for 6 weeks in this case. But the bottom line is the jury understood the concept that even though this 24-year-old student driver, who was still held to the standard of a reasonably prudent commercial truck driver under the same or similar circumstances, didn't follow the rules and didn't do what he should have, that his responsibility paled in comparison to the 65-year trucking company, this $2 billion annual revenue trucking company that put him in this situation, didn't train him, didn't supervise him, put him on a time load that said this thing's got to be out in California in 26 hours.
Well, they had a trainer with him. I mean, wasn't he supposed to be watching him?
He was, and you know where he was?
No.
He was asleep in the sleeper berth, and he had been that way since 5 hours prior to the crash, and it wasn't by accident, it was by design.
Because they put him on a just-in-time road, so they're supposed to be training him, but if the trainer doesn't sleep, then they can't get the load there in time?
That's right. If he's in the passenger seat observing and training and supervising like he's supposed to be, he's on the clock. And hours of service rules say that then he can't drive his overnight shift when it's his turn to drive. And the only way you can get that 18-wheeler from Dallas to California in the time frame that they allotted was to have the wheels moving 24/7. And so this concept of sticking this kid in a situation unsupervised was not an accident. It was the business model and by design. And it's one of the things the jury heard in this case was not only was that the business model for this run, that's the business model for this trucking company. And so they heard evidence that Werner has anywhere from 80 to 100% annual turnover every year, meaning out of their 10,000 drivers, they hire anywhere from 8 to 10,000 new ones every single year. And out of the new hires that they have on any annual basis, 50% of them are just like the student driver in this case, where they come straight from a truck driving school with zero real-world experience behind the wheel before they're hired. And so they've got a whole fleet of drivers that are similar to this, where they have this business model of them sticking them in situations that they aren't prepared to handle based upon their training experience, and people are getting hurt and killed, and the jury heard that and said enough.
Yeah, that's one, scary, and two, speaks volumes about how these companies treat their own employees. I mean, the fact that most of them, like 100%, and the average lifespan of a truck driver working for Werner is less than a year. Not lifespan, but career. So that means that it's such bad working conditions that despite the fact they pay good money, most of them go somewhere else in less than a year. It's crazy.
It's a never-ending revolving door of drivers in and out. You have no continuity. Another way to illustrate that concept is, and the jury picked up on this, rightfully so, was that the trainer in this case was very typical for Werner. But, in our mind, I think, in my mind, and probably for most kind of lay people's mind, when you hear you got somebody that's going to be a trainer of new student drivers, you think of kind of an old veteran, an old pro.
Gray-haired guy.
Gray-haired guy's been doing it a while. Well, the driver trainer in this case, at the time that Werner made him the trainer shortly before this crash, he had been a commercial driver for less than a year.
Oh, my gosh.
He'd held a CDL for 9 whole months, 3 of which were working for Werner before they elevated him and promoted him to trainer. And he told us that the only training that they gave him after 9 months of being a commercial driver, just being now a trainer of people like this fresh out of driving school, was they sent him through a 2-day orientation where it primarily consisted of teaching him how to do the paperwork to handle student drivers.
Wow.
And so, the jury heard that not only was this student driver not prepared based upon his training or experience to handle the situation that they put him in on that day, but even his trainer was in the same boat. And people further up the line, even all the way up to the safety director, were consistently being put in situations that they were not prepared to handle by this company. And it was all about the bottom line. And again, we're kind of just touching the tip of the iceberg here, but it showed a very consistent pattern of a company that made business decisions based upon the bottom line and not based upon keeping the rest of us that share the roads with them safe. And the jury just said, again, this is enough. It's not okay.
And I think that's some of the brilliance of how you earned this verdict, was just so many lawyers would say, well, I got the truck company negligent, I have responded superior, I'm done, I'm going to go home and have a drink. And you worked a lot on this case. How many hours do you think you...
I honestly have no idea. I know we spent a bunch of money on expenses working it up. But, again, it kind of goes back to the reality and threshold that we crossed at the very beginning of this case, was that we had a family that was devastated. We had a 12-year-old girl that needed care for the rest of her life. And if we were going to do any good for them, we were going to help them, it is going to have to be a big number. And the only way we were going to get a big number was through a jury. And we kind of worked it up from that way from the beginning, and thankfully it paid off.
Yeah, absolutely. I was, kind of watching from afar. I played a witness in one of your mock trials, but didn't actually work on your case. But I've seen, you worked harder than anyone I've seen some great lawyers that did a lot of work, but I've never seen someone, between the consultants you work with, the focus groups, the experts, but just the flying to Odessa to see what the people saw in the closest business, the interviewing every firefighter they got out there, the finding the 74-year-old lady that was in a wreck 50-something miles away to talk about her experience, and then finding the truck driver that was there and convincing that truck driver to testify. I've just never seen anyone work that hard, but I guess that's what it takes. If you want to win big, you've got to work hard.
Well, first of all, I appreciate you saying that, and yes, that's my experience. And this was a tragic case, like so many of these are. I love my clients, and I have not had a more gratifying professional experience than to take this case, which was very challenging, but to take these plaintiffs that were so deserving, and conversely take this trucking company that I also think was equally deserving of the justice that this jury meted out, and to have the jury understand the case and deliver the justice that they did with this verdict was enormously satisfying.
I just want to kind of close with the vast majority of the people listening to this, and myself included, have not had an $89 million verdict. So let's say we're starting off as a lawyer that's maybe trying the first Cartwright case, and they want to work up the ranks to get to where you are. What are some things you recommend doing to get there?
Dive in, right? So go try cases, go get experience in front of jurors, go find what speaks to you, whether it be Trial Lawyers College, or go do reptile seminars, or anybody else that you can just go expose yourself to different ideas, different techniques. Be audacious enough to pick the phone up and say, "Hey, my name is Eric Penn. You don't know me, but I want to just spend a few minutes and pick your brain. If you don't mind, this is important, and I want to learn from you." And just dive in. And there's no substitute for experience, and that's, of course, experience trying cases. That's experience talking to people that have done it before, working with various consultants, working with anybody you can, and just go stick your nose in as many things as you possibly can, and then find out what you're good at, what works for you, and dive in.
I agree. It's, and some of these things are there's a little bit of conflict to them, because if you want to get a bunch of trial experience, the best way to do it is to go to a place where you try a lot of cases, which are typically cases that aren't as good. And I'm glad I did that early, because I'm very comfortable in the courtroom. But I think where it took me a long time to get to is you also have to get into an environment, if you really want to be great, where you have time to work on a case.
Yeah, absolutely.
If you were handling 100 cases, you could not have put in the work you put into this one case. And, trying to get to the point where you can either be in a place that has that kind of firm, or be in a place where you're financially secure enough where you can turn down other opportunities and focus on something that's going to be your case. And I think that, you just can't do a great job without putting the work in, and you can't put the work in unless you structure your life where you have the time to put the work in.
Yeah, it's a balance that takes all of us time to, understand first of all, and then try to figure out how you make it right. And we're all still learning. I'm still trying to figure out the right tweaks to perfect that. You and I talked a little bit before you got started today about the 80-20 rule, and sometimes in my office it's more like the 90-10 rule. And I think that's really important to get to a place where you can kind of do that analysis.
And the 80-20 rule is the principle that 80% of your results come from 20% of your work or 20% of your cases.
Yeah, that's right. And when I say 90-10, it's because when I went back and did the analysis to try to understand the 80-20 rule, it turned out really it's more like a 90-10 rule. And so, 90% of my income was coming from 10% of my cases. And so I said, well, why don't I do my best to make sure I spend 90% of my time on those, 10% of the cases? And, it's easier said than done, of course, but I think that's one of the things I've been successful at, for the past 7, 8, 9 years in my practice, is trying to get a lot closer to making sure I'm spending that, the majority of my time on the cases that produce the majority of the income. That's
my big struggle. Is on one hand, I want to spend most of my time in the top 5 cases, but I literally brought in 6 cases today. They're all trucking and commercial vehicle cases.
It's a terrible problem to have.
I know that. I shouldn't complain about it, but it's just one of those, should I take these cases, should I not? But luckily we have a big enough firm where I can parse it out and coach on the ones that aren't the top 5 cases, and then try to spend my time on those that are. But it's such a luxury to be able to actually work and do a case right. It feels so good.
It really is. And you and I know this too. There's not only do you have to have your practice structured where you can make it work financially for you and make it work for your clients, but it's also so hard to find the cases that all those stars align. Where you have the damage model that justifies it, you have a defendant that you can collect from, you have a defendant that sometimes puts up liability defenses that if you and I were defending cases, which we never would, but maybe we would defend it a bit differently, but they defend it in ways that add or create the opportunity for the jury to say this is not okay.
Yeah.
And there's countless others, but you got to have a good venue. You got to have a judge that's going to treat you fairly. But when you do have all those stars align, it is really nice to have a practice where you can say, look, this is the case that I'm going to spend the amount of time and the amount of resources that it needs to do it right. And it's really gratifying. And this, thankfully, was one of those cases where we kind of did that from start to finish. And the results proved that was a case worthy of that decision.
Well, thank you so much. I've really enjoyed talking to you. I've learned quite a bit. I'm hoping that everyone listening did too. If anyone wants to get a hold of you, they want to ask a question, or more importantly, someone has a good case and maybe the stars are in the line and they said, well, Eric Penn got $89 million on a case that seemed impossible. What could he do with a good one? How do they get a hold of you?
Yeah, so it's, my website, I think it's the PennLawFirm.com, and
P-E-N-N?
P-E-N-N. There'll be of course, a phone number and an email address on there, and I'm happy to, just talk through. Again, I am standing on the shoulders of the people that, 10 to 15 years ago in my career, I literally called them up out of the blue and said, you don't know me, but I want to borrow some of your time, and they were gracious enough to give that to me, and so I'm very happy to talk to anybody that's got a case they want to just kind of chew over, please give me a call.
Thank you, Eric. I've really enjoyed talking to you.
All right, Michael. Thank you.
I hope you enjoyed our episode with Eric Penn today. You know, Eric really reminds me that when you work hard and pay attention to a case and do all the right things, good things happen. We all need to make time at our firms to really put the effort in our big cases or our best cases so that we can give our clients the results that they deserve. We're going to go to a different topic next week, how to get those good cases. And we have a renowned person in legal marketing, a guy named Ben Glass. Ben's a lawyer out of Virginia, but he also has a company you may have heard of, Great Legal Marketing. We've had several requests to do more on marketing, and Ben honestly is the person that inspired me to get started on my journey to market. And, we have gone from having a firm that did, smaller cases and car wrecks along with a few big cases to a firm that now only does bigger cases. And using the techniques we learned from Ben helped us make that transition. It was a really great conversation. He shared a lot, and I hope you tune in next week on Trial Lawyer Nation.
Each year, the law firm of Cowen, Rodriguez, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide. Are you an attorney with a catastrophic injury or wrongful death case you'd like to discuss with host Michael Cowen? If so, you can reach Michael by calling 210-941-1301 or send an email to michael@cowenlaw.com. We look forward to talking with you again soon as we continue to explore powerful insights from our amazing host and remarkable guests here on Trial Lawyer Nation. Until then, please be sure to subscribe and review this podcast on iTunes or your favorite listening app so we can continue to reach more listeners. Visit us at www.triallawyernation.com to send us a message, listen to previous podcasts, or learn more about Michael Cowen and our guests. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our hosts, guests, or contributors and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.